Let's talk real quick about spoliation or destruction of evidence in a criminal case. So, what the spoliation of evidence is, it's a legal doctrine that says that if the state has custody of evidence that is favorable to the defendant and they knowingly, intentionally, and maliciously destroy it as an act of promoting their case in chief, that constitutes spoliation. And spoliation, the remedy to that is at law is that if it is determined that the state destroyed that evidence, and this does happen quite often, I've seen it, then the defendant's version of the evidence or his version of the acts accused become the law of the case. And what I mean by that is if, let's say, they say we found evidence that linked an individual to a particular crime, but then they destroy that evidence, well, then it is at that point that the court will state, well, that evidence has been destroyed, it's been spoliated, and therefore there's no linkage to the defendant by virtue of that evidence. You know, they would try to get the state to prove another way that the person was linked to the crime. So that's just a very loose example, but destruction of evidence is a serious thing, something that you need to, always examine if you're going through the criminal proceedings, because we've seen a lot of cases on post-conviction not only get overturned because of this, but also it just seems to be something that's really rampant across the United States.